I'm Sarah Watson. I am the non-birth mother of my son Elias, who's over here. I am a practicing family physician in Wakefield, Rhode Island. And this is my testimony. This is the third time that I'm testifying in support of Bill 5707. I think it had a different number before. And I also support the adoption bill in case that was a question. My son Eli is now 2. He loves books and peanut butter sandwiches and stacking blocks, mainly because he gets to knock them down like baby Godzilla. And I could not be more proud of him. And I'm hoping one day he'll be equally as proud of me. It took my partner and I 2.5 years to become pregnant. I signed more consent forms than I can count. I signed a consent for IVF, which is in vitro fertilization. I signed a consent for donor sperm. I signed a consent for egg retrieval. I signed a consent for embryo transfer. I signed an egg donor agreement, and this was just to name a few. Our doctors wouldn't do any procedures to help us conceive a child without the written consent of both my partner and myself. We were over the moon when we realized that we would finally become parents. And like a crazy person, I even opened up a college savings account for Eli when he was still in utero. In this respect, I was like any other excessively type A first-time parent, but I later learned that the consent forms that I had signed only protected my right to the embryos that my partner and I created, not any resulting child. When my son was born, I realized that I had no presumed parental rights, not one. I wasn't able to put my name on my son's birth certificate, which I know sounds like a formality. I've been told in the past, well, you can still adopt him. And that is undoubtedly true, and I did that when he was 8 months old. But it undervalues his security that it undervalues the legal security that a birth certificate gives a child and his parents to have me not on there. It also highlights that the word parent is being applied differently to my family than it is to other couples in the state. Being a presumed parent is not synonymous with being a biological parent. Whether this was the case in the past is debatable, but in 2019 it is absolutely not the case. Think about your friends and family members. Most of us know someone who struggled with infertility and had to use assisted reproductive technology in order to conceive. Sometimes couples have to use the genetic material of other people, donor eggs or sperm, in order to achieve a successful pregnancy. And I guess here's my question. When these babies are born, does anybody call the anonymous donor the mother or the anonymous sperm donor the father? When the 2 people in the hospital room are the 2 people who fought to welcome this baby into the world, when there are 2 people who've contracted with IVF clinics to conceive a baby, when there are 2 people who intend to parent the child, does it make sense to deny them the title of presumed parent? For opposite-gendered couples, nobody thinks about it. The nurses, the doctors, the staff, everyone assumes if there's a male and a female couple in the room that the baby belongs to them, and the law agrees. There is no test, no request to prove a biological link to the tiny human before leaving the hospital. For married couples, the law assumes that the child belongs to the 2 married people. For unmarried couples, there's a form that you fill out when you're still in the hospital, a voluntary affidavit of paternity, which has a space for a mother and a father. 2 people who may be completely unrelated biologically to the new life. And yet, we allow them to attest to the fact that they are this baby's parents. Why? Because being a parent is not predicated on genes. However, if you're a same-gendered, unmarried couple like me, you can't fill out the voluntary affidavit of paternity. You can't put your name on your new baby's birth certificate. And yes, we can adopt, but the birth certificate is the first and only legal link that a parent has before adopting a baby, unless you get a lawyer. Something legally changes when you go from embryo to breathing human. And the legal right that I have to my embryos does not extend to my son. And I want you to think about what happens to my newborn if my partner died in childbirth, or she'd been unconscious and a critical decision needed to be made about little Eli's life. I would not have been able to protect him. Legally, I can't make decisions for a baby that I have no legal link to. For all intents and purposes, after the birth of my son, I became an invisible entity. And this continued for the first 8 months of his life, despite the fact that I was an equal part in conceiving and caring for him. This never happens to unmarried, same-gendered couples in a similar situation. Ever. I would challenge you to come up with an example. Rhode Island law allows me to foster children. Rhode Island law allows me to adopt children. I am proud to say that Rhode Island is one of only 5 states that mandates insurance coverage for IVF. However, if my partner and I conceive and deliver a child through this mandated IVF insurance coverage, custody of my son remains in legal limbo until we can obtain a court hearing to adopt him. Arguably, I have as much legal standing as the anonymous sperm donor. How is that just? Fortunately, nothing catastrophic happened to me or to my partner, but we need to rewrite the narrow definition of what a parent is to prevent the legal uncertainty that my family faced. This bill is meant to fill in the gaps and secure the rights of anyone who is the obvious parent but not the biological one. Families are not defined by a fertile man and a fertile woman. It's naive to think that this is the case. One would never argue that an infertile man is any less of a father to his son if he and his female partner had to use a sperm donor. So don't treat me like I have to prove a link to my son when no opposite gender couple has to. A birth certificate is an intent to parent, and parents are not homogenous. You don't have to agree with how I've chosen to live my life in order to see that my son was put in a pretty precarious spot for the first 8 months of his life. There was never 1 second where I wasn't my son's mom, and there was never anyone else standing up saying, "This kid's not yours, he's mine." It's imperative. We need to make it easier, not harder, for parents like me to secure a relationship to our kids. There are currently 2 standards for parenthood in this state. One, seamless, for unmarried, opposite-gendered couples, where they get to walk out of the hospital with all of the parental protections afforded to married couples. And there is a second, fraught option for same-gendered, unmarried couples in Rhode Island that leads to uncertainty, anxiety, and fear until they adopt their kids. Who benefits from this law as it stands now? Who exactly are we trying to protect? I can tell you that you're ignoring my son's right to the security that comes with 2 legal parents. My son, who statistically will likely grow up to be a heterosexual individual, much like your own sons and daughters. So why are we not protecting him?